My Lords, I'd like to dedicate this speech in a way to Lord Cormac, if I may, because the last time I spoke to him we discussed this very issue that I'm going to raise, and I make no claim that he'd agree with me, just that he, as was his wont, he was very supportive of me putting in this amendment, and I wanted to acknowledge that whilst I know he didn't agree with me on many, many things, he was still a great peer. So, to Amendment 148E, which is looking at identity changes and recording on registers. On the front page of Scottish newspapers over the weekend was the story of Mark Sherland, the head of the Robert Burns Federation, who has been unmasked as a convicted sex offender who abused 2 boys in the past. He got the job by exploiting a legal loophole, and that meant that he, Douglas Hammond, which is what his name was when he committed earlier offences, he changed in order to get the job. Chillingly, his role at the Federation allowed him access to children. Now, thankfully, instances of sexual offenders changing their name to escape their past are being tackled, not least by the efforts of campaigners for Della's Law, named after the 6-year-old Della Wright, who was raped by a man who had legally changed his name 5 times. And I'm glad that the government has endorsed amendments to the Criminal Justice Bill that will block offenders from, for example, using deed poll to obtain a new identity. I particularly want to congratulate the Honourable Labour MP Sarah Champion, whose private members' bill, the Community in Suspended Sentences Notifications of Detail Bill, passed its second reading in the other place only on Friday, 23rd of February, and I congratulate the government for signalling its support for that private members' bill. It is indeed designed to tackle the fact that hundreds of sex offenders across the UK slip off the radar because they change their names lawfully and then apply for fresh identity documents, allowing them to escape the authorities, to escape their past, and potentially to secure jobs working with children. Now, you might say that because of the private members' bill that I've just mentioned and the government's support for it, that there's really no need for my amendment because it deals with what I'm worried about. But when we're told that Ms Champion's bill will mean that all offenders will now have to notify their probation officers, etc., about any name changes, online aliases or changes in contact detail, actually perhaps not all offenders are covered by this at all. So my amendment is probing another loophole that seems to have gone beneath the radar, and I do hope that the Minister will address this. I don't necessarily mean now this evening, but before we get to report stage. That's what I'm hoping will happen. The new arrangements that I've discussed about not allowing sex offenders to simply change their identity to escape their past crimes means that, and so registered sex offenders won't simply be able to change their identity on official documents. It's true for everyone, except that there is a little-known exemption that exists in relation to a sensitive applications clause that applies to those who have changed their identity not simply via deed poll, but via transitioning gender. This sensitivity clause is one which can be utilised by convicted male sex offenders who change gender post-committing their crime once they're incarcerated. How I discovered this loophole was a bizarre tale that ended up being rather personal to me. Kerry Lee Galvin is now a delightful 25-year-old mum who was training to be a paramedic. Well, Kerry Lee had a traumatic, hellish childhood. From the age of 8, she was sexually abused and raped by her own father, Clive Bundy. This horrendous ordeal went on for 8 years until eventually Bundy was arrested in 2016 and sent to prison for 15 years. Having served only half of his sentence, Bundy was released on licence less than a year ago. Now, whatever the rights and wrongs of this seeming early release, and I think it was unseemly that Bundy was released so early, at least you'd think, well, OK, that's been agreed, he's been released. Clive Bundy will be in clear sight of the relevant criminal justice agencies to protect in terms of safeguarding. Except there's a catch, because 2 years prior to Clive Bundy's release, he declared himself a woman and changed his name to, wait for it, Claire Fox. And for those of you who only know me as Baroness Fox, my name is Claire Fox. So I noticed when I heard this story. Think what that means. It means that a Clive Bundy might well be on the sex offenders register, but Clive Bundy doesn't exist anymore. Clive Bundy is Claire Fox. Clive Bundy wasn't let out of prison early on licence. Claire Fox was. And what is more, the proposed new changes on restricting identity and name change via depot that I've already discussed won't apply to Clive Bundy. Why? Because when someone changes gender as part of changing identity, and it makes no difference, by the way, whether that's achieved by self-declaration or in accordance with the provisions of the Gender Recognition Act, they are afforded an extraordinary enhanced right to privacy, wholly unlike those granted to any other individual. And then these special protections given to them by the state, I think, represent a concrete safeguarding risk. It means there's a loophole that's been created whereby an individual is able to conceal their past identity for the purposes, for example, of disclosure and barring service of DBS checking processes. An individual such as Clive Bundy can request, based on this privacy special category that he's in, can request that his past identity or name is not displayed. Now, I'm confusing you because it's not Clive Bundy anymore. Claire Fox can say, I don't want the name Clive Bundy to be displayed on any DBS certificate issued to me. My name is Claire Fox. And what's more, a prospective employer isn't entitled to know whether a candidate has used this sensitivity clause to cover up who they are. And a reminder that DBS checks are supposed to play an important role in safeguarding by helping organisations make safer recruitment decisions. They are designed to both deter unsuitable people from applying to work with vulnerable groups and to assist organisations to identify and reject unsuitable people. But organisations are only able to rely on the DBS checking process to the extent that checking systems are robust, that the information displayed on DBS certificates is both accurate and complete. But thanks to the work of people like Kate Coleman and the campaign group Keep Prison Single Sex, KPSS, we now know that these sensitive application loopholes mean that organisations have no way of knowing whether or not information displayed on DBS certificates presented to them is an accurate or complete record concerning any individual. And think what that means for Kerry Lee and her paedophile father. Since his release, Clive Bundy, Claire Fox, has gone to live in the same town as his daughter. That means that he could apply for jobs locally, working with children, even working with Kerry Lee's own daughter, and his past would be hidden. And it's worth noting that due to the special privacy rights afforded to Bundy, Kerry Lee had no right to know, Kerry Lee, the victim, had no right to know of Clive's gender transition and only found out when Bundy gave permission for the information to be passed on via Kerry Lee's victim liaison officer, part of what writer and activist Julie Bindale described as an example of coercive and controlling tactics. But the key issue is that there's no legal requirement for a victim to be warned. So Kerry Lee wouldn't have had any idea that Clive Bundy, had been erased, and that the new person who'd entered the town, Claire Fox, was in fact her father. And therefore there would have been no alert to the family children about if they were being shown attention by a local employee called Claire. I stress the familial connections point, by the way, because grossly Clive Bundy's argument at the parole board about why he didn't represent a threat to wider society was because his incestuous abuse had been kept within the family. Think of that as a sick retort. So just in my rounding off remarks, I'm keen my Lords note that this amendment has been driven by Kerry Lee's experience rather than my own views on gender identity, which I know not all noble Lords will agree with me on. But Kerry Lee is not involved in gender politics. She got dragged into this by her paedophile rapist, who, she notes, my father wasn't dysphoric about his male genitals when he was abusing me. And in a way, also, I've been dragged into this issue by Clive Bundy using my name. When the story was first made public in the other place and then in the press, I was mortified and wished it would go away. Somehow it was just so embarrassing having my name being sullied by such association with a perpetrator. But then, when I thought about it and heard Kerry Lee had broken her own anonymity, it gave me a jolt. Kerry Lee appealed to those of us with influence to help her expose the loophole that could allow dangerous sexual predators to evade detection and potentially target other child victims, perhaps in female-only settings. Kerry Lee knows that it's too late in her case, but it doesn't have to be for others. And I hope, therefore, that we can perhaps create a Kerry Lee law.
Amendment proposed after clause 47, insert the following new clause and insert the words as printed in the Marshall list.
My Lords, Lady Fox started her speech by talking about sex offenders changing their names frequently, and there is no doubt that this does happen. I'll come on to explain why I think that there is help in that. But her amendment seems to be intending to strengthen identification of individuals on licence who have a different gender assignment to that given at birth. It implies a perceived need to know that person's birth gender, and legal identity, and that they're relevant to the prevention of a sex crime. My Lords, this, as Lady Fox, I think, is aware, is highly contentious and a very sensitive topic with implications for the equality, dignity and fair treatment of transgender people. His Majesty's Prison Service estimates that there are approximately 2.9 transgender prisoners per 1,000 in custody. There were 281 prisoners living or presenting in a gender identity different to their birth sex as at the 31st of March last year. The number of prisoners at the same time with a gender recognition certificate is only 13. HMPPS already has robust arrangements in place for identifying individuals who've undergone gender change at the point of entry to custody. And that's because there are already rules inside prisons for making sure that there are no risks to the prison population or indeed to those who've changed their gender, because sometimes they are attacked as well. Nevertheless, even if an individual somehow managed to slip through the net, establishing it would require staff checking the legal gender for every person convicted of a sex event who was released from prison, effectively trying to prove they do not have a GRC by asking the gender recognition panel. And subsection 2 of her amendment talks about the database recording absolutely everybody. Data published who has committed a sexual offence in their gender at birth. Data published on the 31st of December last year shows that there were 14,152 people in prison serving a sentence for a sex offence. I wonder if the Minister would care to hazard a guess at how much time would be spent asking HMPPS and the GRC to trawl through that lot. HMPPS is required to accurately record a person's legal gender upon entry to custody, and the policy states that where legal gender has not been confirmed, efforts to establish the legal gender must be recorded separately when different, so both are still recorded. Furthermore, I remember that during the course of the Police Crime Sentencing and Courts Bill in 2021, the noble lady, the Baroness Williams, on behalf of the government said, "There are no other instances across government where there is a mandatory requirement to record both a person's sex as registered at birth as well as their acquired gender, if that is applicable. The Office for Statistics regulation is clear that it is for each department to decide when and how it will collect data, including data on birth, sex and gender. We've already stated that we do not plan to require biological sex to be recorded across the criminal justice system in our response to a recent petition calling for the biological sex of violent and sexual offenders to be so recorded," end quote. So, my Lords, given that, given the protections that the prison service must follow through with every transgender prisoner, I'm actually wondering if there is actually a real reason for the need for this particular amendment. And I appreciate the tale that she gave us from the individual, but I'm not sure that what she requires in this amendment would actually help the victim in this particular case.
I think that I echo the noble Lady Baroness Brinton's worry about this, partly because it may not solve the victim problem that the noble lady has outlined in proposing this amendment, but also I think there's how can I put this? Well, we've talked a lot about the unevenness of the criminal justice system's data collection and everything else, and I'm just kind of wondering how on earth they would do this for solving what is probably a very, very small problem. I mean, a challenge, absolutely a challenge, and that there may be another way of resolving it. So I look forward to the Minister's remarks on this.
My Lords, I'm very grateful to the noble Baroness Lady Fox for explaining the background to her amendment. The amendment would require by law that the criminal justice agencies, the police, prisons and probation, identify and record any change of gender identity by a sex offender as a condition of their release on licence. It would also require the police to record the offender's name and birth sex as a condition of their release on licence. It may help if I outline the measures we already have in place, which I think do address the spirit of this amendment. Part 2 of the Sexual Offences Act 2003 requires sex offenders who've been convicted of an offence in Schedule 3 of that Act to notify the police of their personal details annually and whenever they change. Those details include information such as names, including aliases and addresses. They also include details of activities such as foreign travel and residence in a household with children. Sex offenders subject to the notification requirements in Part 2 of the 2003 Act are managed under the Multi-Agency Public Protection Arrangements, or MAPA. MAPA is a statutory arrangement through which the responsible authority, the police, prisons and probation, work together and with other agencies to discharge a statutory duty to cooperate, to assess and manage the risk posed by registered sex offenders and others living in the community. In February 2023, the Ministry of Justice and His Majesty's Prison and Probation Service created a presumption that all transgender female prisoners, whether they have a gender recognition certificate or not, would not be held in the general women's prison estate. The prison service is able to verify with the gender recognition panel whether an offender has a GRC, gender recognition certificate. Any difference between an offender's birth sex and assumed gender will therefore be recorded and made known to the probation and police services through their cooperation under MAPA. The MAPA responsible authorities use the VISA database to share information about registered sex offenders. VISA enables the recording of sex, gender identity, and gender presentation. An offender's legal sex will be changed on VISA only if they have provided a GRC to the police, probation, or prison service. However, MAPA agencies are still able to have regard to an offender's change of gender where it is necessary to manage their risk or prevent or detect crime. While Section 22 of the Gender Recognition Act 2004 makes it an offence to disclose information about an individual's application for a gender recognition certificate, there is an exemption for this where disclosure is necessary to prevent or detect crime. Accordingly, should the police or any of the other responsible authorities require information about an offender's application for a gender recognition certificate, this can be obtained by working with relevant duty to cooperate bodies such as medical professionals. So I hope, my lords, the noble Baroness will find this information helpful, and whilst I'm of course willing to write to her if I haven't picked up any subtleties of the points that she raised, I hope she will feel comfortable at this stage in withdrawing her amendment.
My lords, well, thank you very much for the responses that I've received, and I think that I will take off what the noble lord, the minister, has said and look at it myself, and maybe we can both clarify whether we've missed anything. I don't want to delay us too long now, so I would say to the noble Baronesses Thornton and Brinton, that if the wording of this amendment is not correctly going to pick up the problem I've identified, I'd be happy to take their advice on how to improve the wording. But I think it's a genuine loophole that does exist. I was a bit concerned when the response seemed to be to suggest that there would be a lot of work involved in solving a small problem. I think that as I've listened to such passionate speeches from the noble Baroness Brinton and Thornton about, for example, the kind of threats to women and girls in particular from, for example, stalking, the importance of child protection and so on, I would have thought that any opportunity to close down a loophole on safeguarding would have been grabbed by the noble baronesses, and I do hope that they will work with me. I've already identified that the loophole in general of sex offenders changing identity has been identified by the Labour MP, backed by the government, and I've simply drawn attention to a loophole within that loophole that was being closed. I used particularly the example of DBS checks, and DBS checks are very important, and I've always thought the government went slightly over the top with DBS checks for volunteers or people working with the Brownies or what have you in the past. But if you're going to have them, you need to be able to rely on them. And so when the noble Lord Minister said in his assurances, I didn't feel that that would capture the DBS point. And that's what I've tried to do in the amendment. It will be improved. I will be back for report. But in the meantime, I withdraw the amendments, and I'm glad that people appreciated the spirit of it.
Is it your Lordship's pleasure this amendment be withdrawn? Amendment is by leave withdrawn.